When you are arrested for DUI, and a passenger is also cited or arrested the same night, California courts treat each of you as a separate defendant. The prosecutor opens a separate file for each person. Your guilt or innocence is judged on your own conduct, not on what the passenger did or did not do. That said, the fact that a second person was arrested that same night can affect your case in ways that are not always obvious. The most common co-arrest scenario is a passenger cited under Vehicle Code 23222, the open container law. If an open bottle or can was found in the passenger area, that evidence will appear in your police report too, and prosecutors can use it to argue that drinking was happening inside the vehicle. A second scenario is a passenger arrested for drug possession under Health and Safety Code 11350. Officers may use that discovery to support a theory of a drug-influenced environment, even if your DUI charge is based on alcohol alone. Both situations make a close review of the officer's notes and the evidence chain essential. You and your passenger should not share an attorney. When two people are arrested at the same scene, their legal interests can conflict. Your passenger might benefit from saying something that hurts you, or vice versa. Each defendant needs their own independent lawyer, reviewing their own facts. Do not wait to see what happens with the other person's case before you act on yours. A passenger who was in the car has first-hand knowledge of everything that happened before and during the stop. If that person cooperates with the prosecution, they could testify about how many drinks you had, how you were driving, or what you said at the scene. The other side of that is also true. A passenger who saw the officer skip steps in the walk-in turn test or administer the horizontal gaze nystagmus test incorrectly could be a witness in your favor. Your attorney needs to evaluate this early, before memories fade and before the other party has locked in a story. A co-arrest is not only a complication. It can open lines of examination in your defense. If the officer spent significant time processing the other person, there may be gaps in the timeline between when you were driving and when a breath or blood test was given. A longer gap creates room to examine the rising BAC argument, which looks at whether your BAC was still climbing at the time of the test, rather than reflecting what it was while you were driving. Procedural errors that happen while an officer is managing two suspects at once may also show up in the paperwork and become worth examining. The criminal case and the DMV administrative case run on separate tracks. The DMV suspension process belongs to you individually, and the deadline to request a hearing to contest your license suspension does not pause or shift because another person was arrested that night. Missing that window means an automatic suspension. Your sentence, probation conditions, and any ignition interlock decision under Vehicle Code 23538 will also be set based on your own record and your own facts. What happens to your co-defendant at sentencing has no direct bearing on what happens to you. If you were arrested for DUI and someone else in that car was also charged, the cases may feel connected but the outcomes are separate, and yours depends on what you do in the days right after the arrest. I'm Joel Brand, a California DUI lawyer. This is general information, not legal advice. If you want a free written case analysis, it is at DUI.guru.